Supreme Court made a big decision regarding the Deferred Action for Childhood Arrivals program recently, also known as DACA. Joining us today is Dale Wilcox, the Executive Director and General Counsel for the Immigration Reform Law Institute in Washington, also known as EARLI. And also with us, Christopher J. Hajec, Director of Litigation at EARLI. And Dale, we had this big case come down last week. What was the question before the court and how did they respond?
Well, what the court was doing, it was looking at the Trump administration's rescission of President Obama's DACA program. And what some people might not understand here, the court was not really looking at whether DACA was legal or not. What the court did was the court analyzed whether the president followed the Administrative Procedure Act in rescinding the DACA program. And what the court, the bottom line, the court said no, the president, his actions were arbitrary and capricious. He did not give sufficient reason for rescinding the DACA program.
Mm-hmm. Now, Dale, how relevant is it that they did not comment on the legality of it? Does that leave the door open then for a possible different decision down the road?
Yeah, absolutely. What the court did was it stated, okay, Trump administration, you didn't follow the correct procedure. It didn't rule on the legality of DACA at all. So that question is still out there. And the court essentially gave the Trump administration a roadmap. Okay, go back to the drawing board. So this case really isn't over in a sense that the Trump administration can issue a new rule rescinding DACA and follow the Supreme Court's guidance in this recent opinion.
Mm-hmm. Now, Chris, there was a lot of analysis after this decision came last week, and one of the questions people were asking is, how is it possible that President Obama was able to implement DACA via a policy memorandum, and President Trump, by the ruling of this court, is apparently unable to reverse a policy using the same kind of memorandum?
Well, I don't know if he couldn't reverse it with a memorandum. If the memorandum had different things in it, it would have been enough. Mm-hmm. But the Chief Justice found it insufficient because all they did was say, we're rescinding this because it's unlawful. And, just as the Fifth Circuit has held, and a very similar program, DAPA, was unlawful. For those reasons, and because the Attorney General has given us his opinion that it's unlawful, we're rescinding it. The Chief Justice thought that they had to consider the reliance that DACA recipients had placed in this program and the effect that it would have on them to just rescind it and say something about that. He didn't say what they had to say about it. There are a number of options. They don't have to change anything or not rescind it because of that, but they had to address that, the Chief Justice felt.
Mm-hmm. Now, Justice Alito mentioned in his dissent that the decision would effectively delay any remedy for DACA through the end of the current presidential term. Given that and the length of time it takes for these cases to come back, what is the fastest way that this issue will be before the court again, or that it can get the result that people against the program are looking for?
The fastest would be if Judge Hainan ruled immediately and the program were enjoined. That would happen very quickly. And of course, it would be appealed and go to the Fifth Circuit, but that would be upheld if, based on that earlier case, which was the same program as DACA. Now, at that point, the Supreme Court could take cert or it could not. It might not ever go up to the Supreme Court. If the Fifth Circuit affirmed Hainan's injunction, the Supreme Court wouldn't have to do anything and it would be enjoined.
Can you give a little background on that for people that may not know the details? There's a case in Texas right now.
Yes, Texas and other states are suing to end DACA. Earlier, the same states or a similar group had sued the much bigger DAPA program, Deferred Action for Parents of Americans, I think that stood for, and that included an expanded version of DACA. And Judge Hainan found it all unlawful. including the expanded DACA, and enjoined it. And that injunction was affirmed by the Fifth Circuit. And then it went to the Supreme Court. And just before the Supreme Court ruled, Justice Scalia died. And the remaining 4 conservative justices voted to affirm the Fifth Circuit, and the 4 liberals voted not to. And so the case was affirmed without opinion, so it's not precedential from the Supreme Court.
Dale, a lot has been said since President Obama instituted DACA about how he went about it the wrong way, that it's not legal. If this program were overturned, what would that represent in terms of U.S. immigration law?
Well, certainly it would rein in these executive actions that President Obama attempted. As Chris had noted, DAPA was successfully defeated. President Obama attempted to legalize 4 million plus people with that program. With DACA here, we're talking about between 700,000 and 800,000 people who have signed up for DACA. Potentially there is, it was estimated there is a class of about 1.5 million people who are eligible. But you've only gotten about 700,000 or 800,000. So, you know, a good ruling here would restore rule of law. It would send a message to future administrations that you cannot violate the INA, our principal immigration law. You can't go out on your own and just start handing out work permits and status to aliens. So it's important that we continue the fight on this issue. We've you know, you feel bad for these DACA recipients because truly, yes, they were brought to the country by their parents when they were to be eligible for DACA. When it first came out, you could be as old as 30 years old. I mean, these aren't children. However, you had to be brought to the United States when you were 16 or under. And, you know, you feel your heart goes out to these people, but it's not the United States problem. It's their parents. Their parents put them in this position. And it's sad, but we do have borders. We do have laws that immigration laws that do allow people to immigrate here legally. And there is a long line of people waiting. Last I heard, 4 million plus waiting for their number to come up who have applied. So, you know, those people who are enrolled in the DACA program have jumped the line, essentially, and that's not fair. So that's why we're fighting for this. We're fighting for the rule of law. We're fighting for you know, our immigration laws as passed by the people's representatives.
Yeah. Chris, you mentioned about the case in Texas, but the Supreme Court essentially told DHS to start over again on its proposed fix for DACA. Did they give DHS specific things it needs to do, or is it clear what DHS can do or should do?
It's not absolutely clear. It looks like they could write another memo and include things such as a discussion of reliance interests that the DACA people have, and explain more why, though I think they did explain it the first time, why the deferred action part of DACA, which is the Chief Justice made much of, the forbearance part, is also unlawful. It was unlawful if only because they didn't get notice and comment when they did it. Now, to be absolutely safe, I would advise the administration to issue a rule and put it through notice and comment and make it impossible to challenge. Mm-hmm. Because writing a memo treats it as just a policy memo when really it's a substantive rule. And substantive rules have to go through a notice and comment period where the public can comment on it. And and then the final rule issues. It's all just procedure, but the more procedure they lay on, the more likely it is that it won't even be challenged. Or if it is, no district court would block it.
Mhm.
So it's almost like that they just shouldn't want to leave any opening for the courts to interfere.
Dale, there was a lot of criticism of the court after this decision came out, in particular for Chief Justice Roberts. It seemed like the approach of it was something along the lines of, we're going to allow this very questionable program to remain in place while the administration has to do these things to fix it. Why did they choose that path versus declaring the problems with DACA and forcing the supporters of it to make the changes on their end?
Yeah, that's one of the, if anybody wants a good snapshot of our argument in this case, read Justice Thomas's dissent in the opinion last week. A great summary of our argument. Justice Thomas said, look, this was illegal from the start. This was a substantive rule. Not only did it not follow the APA, the Administrative Procedure Act, requirements for a substantive rule, notice and comment, as we've talked about here, but substantively, this thing violates the INA, our immigration law. So it's illegal. So Thomas is arguing, how can you order DHS to continue to implement an illegal rule? It makes no sense. What the court should have done, and Chris, I believe you've argued this in the briefs, they should have gone back to status before DACA was issued, not to an illegal rule, but they should have gone back even further, earlier.
Right, if they go back to that, and they should have decided all that to decide their jurisdiction, because if you go back to that, it doesn't help the plaintiffs at all. And so they can't win in this case if the court were only determined not to give effect to an unlawful program. And if they simply had that rule that Justice Thomas assumed they had, then they wouldn't have jurisdiction, and they just would have dismissed the case. And also, but that would have involved them in holding that DACA is unlawful. And I think that the Chief Justice was very reluctant to do that for whatever larger reason that might occupy his, thinking.
Mm-hmm. Chris, do you think there's a chance that if DHS makes the changes, that the majority, which includes the Chief Justice, are going to, in effect, move the goalposts and change the criteria the next time something comes up?
Well, they should make sure that can't happen. I mean, the administration should, because, it's not perfectly clear where the goalposts are. It's pretty clear, but I think they should, as I said, do everything possible to make it unchallengeable on these procedural grounds. There's just no point in getting the courts involved again.
Mm-hmm. Now, on a related topic, Dale, there's a report out now that the president is going to suspend H-1B and other work visas through the end of the year. On the other side of this coin now, that's probably going to spur lawsuits challenging that. What do you make of the legality of this use of presidential authority?
Well, we've argued this issue in several cases. Chris probably could speak better to that, but I'm sure the president's going to use his ability under the INA to suspend all immigration or immigrants and non-immigrants into the country. And he absolutely has that power. In the travel ban case, the Supreme Court affirmed the president's power to, because of national emergencies, and of course, COVID-19 would qualify. We have 40 million plus unemployed currently who would need those jobs. So the president has the grounds to suspend all immigration and non-immigrant visas. So it would include H-1B guest workers, and he could suspend the OPT program. He could suspend the H-4 visa rule that we're challenging in court that President Obama issued in 2015. Chris, do you want to speak anything to that?
I would say that's absolutely right. And I would only add that in the legislative history of that provision, the sponsor of the bill said we need, the president should have this ability in the future if there's a time of high unemployment to protect American jobs, and that's exactly what the president's doing right now because of the record unemployment resulting from all the shutdowns.
Okay. Dale, anything else you want to say in closing regarding the Supreme Court case or the case in Texas and what's to come?
Sure. This case wasn't a total loser, as some people suppose. Actually, there were some good things that came out of this case. Yes, we would have liked to have seen the Chief Justice vote with the other four conservative justices that DACA is illegal. I think that was the easy, courts who have analyzed DACA have found this, that it was Obama was not authorized to do this. And in fact, Obama stated previous to issuing the DACA proclamation that he didn't have the authority to do this. He's not king. But he went ahead and did it anyway later, right before the election, his second election, to appease his constituents there. But anyway, there were some good things that came out of this opinion. Number one, the majority opinion ruled that DACA is not just a mere non-enforcement policy. Now, see, the government, when they were defending DAPA in the Haining case in Texas, the Obama Justice Department was trying to argue that, oh, this is just prosecutorial discretion that we're exercising. We're just deciding to defer. We're just, they're not priority for us, so we're just going to defer going after them and deporting these illegal aliens. Whereas the majority here last week ruled, no, this is not just prosecutorial discretion. This is just not a non-enforcement policy. This is a substantive program he created. I mean, thus, signaling its death knell, because it should have went through public notice and comment under the APA. So it's procedurally defective under the APA, not just substantively defective. The second good point out of this opinion, the plaintiffs had brought equal protection claims against the president, arguing that he was rescinding DACA because he's a racist, because he has racial animus against people of color. And the majority of the court, and I believe it was only Sotomayor, she was the only one to disagree on this point. The majority of the court said, no, there's not enough here to prove racial animus. And in fact, the Chief Justice, in his opinion, stated that because it has been argued that these immigration actions hamper Hispanics mainly. And the Chief Justice Roberts argued, look, the majority of people in the country unlawfully, or, the majority of DACA recipients are Hispanic. So that would mean that the president couldn't take any action because it disproportionately affects a certain ethnic group. And the court thankfully said, no, that's not true. That doesn't show violation of equal protection or racial animus. So we've seen that argument in many lawsuits around the country, not just with DACA. But Chris, I believe that they raised that argument even with the travel ban, and in the Fourth Circuit.
Yes.
That argument's been around a long time. So hopefully this decision will put a stop to those types of arguments. Right. So, the opinion, it wasn't, I wouldn't call it, a loss in that regard. It's more like a delay. And we have the case down in Texas, and I think that's the quickest way, the fastest route to ending DACA. And I think that's the way it's going to end. But the administration has recently signaled its intention to go back to the drawing board and come out with another rule rescinding DACA.
Chris, anything else you want to add in closing?
No, I think that's about sums it up. I mean, it's not a total loss. The removal of that equal protection argument is very important, and will save a lot of time because courts won't have to go through that in subsequent cases, in the present case.
Okay. All right. Well, we'll leave it there. Guys, thanks for joining us.
Thank you.
Thanks for having us.